I'd like to first start with the parenting plan that was proposed by Ms. Lindsay. Mr. Lindsay, do you have any objections to that proposed parenting plan order?
I don't believe so. Given the length of time that's left, and the age of the child, I believe we're going to leave visitation up to when the child decides. As what was stated in the decision that you asked us to write orders for. I think it's probably fine.
Okay. All right. I'll adopt that proposed order and sign off on that. Then, as far as the quadro, which is the qualified domestic relations order, which is the order that's used, it's the mechanism by which retirement counts are divided. Mr. Lindsay, do you have any objections to that proposed order? It's the title is top right corner. It says dividing retirement accounts and marriage dissolution, split plan 3 plus DCP template, and then right below that in large letters it says order dividing retirement accounts and marriage dissolution.
Yeah. Other than I believe she had mentioned that there was a second account or something like that. She was trying to basically double dip as far as the dividing the account based on its value at the time of separation. That's fine.
Okay, I'll sign off on that proposed quadro order. Then on to the findings and conclusions about a marriage, or the findings of fact and conclusions of law. There, I'm looking at Ms. Lindsay's proposed order under paragraph 8. That's the only area or paragraph where I see that there's discrepancy with what the court had ruled previously. So in paragraph 8, it says the spouse's real property is the 3731 Columbia Heights Road, Longview, Washington, parcel number, and that it indicates that it's the respondent's separate property, and then it says that the division of real property described in the final order is fair and just and equitable. The final order, if you look at the final divorce order under paragraph 7, it says that the property is to be given to Ms. Lindsay, which is not accurate. And that's contrary to the proposed order. Contrary to the court's order that was written. So I'm then going back again to the findings of fact and conclusions of law document. So under paragraph 8, the spouse's real property is listed below, real property address, tax parcel number. It should be listed there instead of respondent separate property, it's community property. I'm scratching out respondent separate property. And then the conclusion of the division of real property described in the final order is fair and just and equitable. I'm fine with leaving that language in, but we need to then adjust the dissolution decree, which is titled the final divorce order, which is prepared by Ms. Lindsay. So let's look then at paragraph 7, where it says real property. Says the real property is divided as explained below, where it says given to which spouse is that spouse's separate property. So it should not, I'm crossing out respondent. And I'm putting that that property shall be listed and sold with split evenly.
Your Honor, there was some paper shuffling or something when you said that property to be listed and sold, and then you broke up.
And then proceeds to be split evenly. And then the paragraph right below that box in paragraph 7, I'm striking that portion. That's not what I ordered. Then below that is the quiet title case related to 20-2 602-08. That quiet title case was not the subject and was not raised in the trial before the court when the court heard the matter. I see that there was back in March, there was this partial summary judgment order related to an adverse possession claim that was granted in favor of the Iron Homes, I believe, and then Ms. Lindsay's adverse possession claim was denied in that partial summary judgment. So where does that case stand, Ms. Lindsay?
It's still going forward.
What's the issue that's unresolved?
The timber trespass.
Okay. All right. So since the court wasn't apprised of that at the trial, the court made a ruling. I'm not going to adjust my ruling, so I'm going to strike that paragraph below, which says other. There is an ongoing quiet title, so I'm striking that. And then on page 1 of that final divorce order, the dissolution decree, where it says summary of real property judgment, there it basically will list the assessor property tax parcel number with its description. And that's just summarizing it from section 7. So basically there's not a grantor nor a grantee. Basically the property is to be sold, listed and sold, and proceeds divided evenly. Other than that, when I was looking through Ms. Lindsay's proposed final dissolution order with the updated or revised numbers that basically amended account numbers to make sure that those were accurate, they seem to be, those same numbers seem to accord with what I had listed in my ruling and seem to accord with what Mr. Lindsay had listed in his proposed order. So I'll ask then, with those revisions that I've mentioned here to paragraphs 2 and to paragraph 7, does any party have any objections to that final proposed dissolution decree presented by Ms. Lindsay?
With the exception of the WSECU, I had listed it in my original orders before the hearing, and it appears to have not made it through to your decision. That is about almost a $15,000 debt that is shared.
Okay. Ms. Lindsay, do you have any comment on that, on the WSECU?
No, I don't. He didn't provide any discovery, so I don't have any comment.
Okay. So, Mr. Lindsay, on your proposed order, you have the WSECU listed in exhibits D and E, but there's two different figures, the 7,400 and the 6,600.
Yes, Your Honor. If you look at it, the math is the 53-47 split you had suggested on future debts found but not listed in the order.
Okay, and the 53% relates
Would be me.
Okay. For a moment. Okay, and so let me ask. So when the case was tried, was there any testimony presented by, or testimony or evidence presented by either party related to the WSECU?
I did, Your Honor. That money was used to pay for back taxes on the property, pay off the second mortgage that was on the property, and to pay some legal fees for her defending the property against Iron Homes.
Objection. There's never been back taxes ever owed on the property.
Okay, the due taxes.
I've always paid my bills.
So I guess more to the point, my question was at the trial, Was there any particular mention of the WSECU?
No, Your Honor, it was listed in my, I mean, we did talk about it.
I'm looking at my notes and I typed in WSECU under the direct examination or testimony of Mr. Lindsay. He indicated under debts, he talked about paying off Ms. Lindsay's debts at a lower interest rate, that he paid her lawyer and taxes. Said he had no idea about First Savings, no idea about Ally Mission Lane. He talked about that. And then he said 3 debts are his. These are my notes. Upgrade for 1,000, Mercury for 3,000, WSECU for 14,000. And then the next reference I have in my notes is Mr. Lindsay testified that he took out equity loans to pay off loans and that he took out a personal loan from WSECU to cover debts in 2019, roughly $14,000. So it looks like it was the subject of, there was testimony related to that.
Yes, sure.
And apparently I that didn't make it into my ruling, and I'll just double check my written ruling from May 21st, which I don't think it made it in there.
Nothing happened in 2019. That personal loan that he's talking about was not for me at all.
Okay. So I'm just looking at the debts assigned, and it's omitted from my ruling, and there was testimony related to that. So there's a provision in the proposed order of Ms. Lindsay's final divorce decree. Let me just go to that and see if that potentially resolves the issue. So let me take a look. All right, so I'm looking on page 6 of 7 of Ms. Lindsay's proposed final divorce order. It's under paragraph 20. And this is again on page 6. It says any debts not specifically awarded herein incurred by either party shall be 100% the sole and separate financial obligation of the party who incurred the debt and who failed to disclose it in this final divorce order. If an undisclosed debt is incurred by the parties jointly, then the parties shall remain jointly liable.
It was disclosed.
Yeah.
It was jointly.
Okay. So I think since it was the subject of of trial testimony, that I'm going to list that here, the WSECU. Under each, I'm going to award each roughly for Mr. Lindsay, who's the petitioner. I'm going to award 53% of that debt to him, and then 47% of the debt to Ms. Lindsay. So I think that resolves that particular issue. Then I'm taking again a look at the final divorce decree on paragraph 20, the retirement account. Next one down is life insurance on page 6. The 2 children's life insurance policies, 1945 and 1579, are awarded to a respondent. Any objections to that, Mr. Lindsay?
No, Your Honor. I believe they may be in her name. If not, I will sign them off. They are current, although she's got me in court in another couple of days on contempt for not keeping them current.
Okay. All right, so I'll leave that in. Then as far as any other concerns related to the final divorce order or dissolution decree, does any party have any concerns that you want to address?
Just the timeline for the liquidation of the residents and
Yeah.
Getting my belongings as well.
So let's take a look on the divorce decree proposed by Ms. Lindsay on paragraph 8. I think that's where it lists that relates to that. It says under, where it says on line 17, paragraph 8, it says other petitioner shall take possession of and remove from 3731 Columbia Heights, any, where such, or any other property or location where that may be stored, all vehicles and related property awarded to him, this shall occur no later than 60 days after the entry of the order. So I think that's appropriate. And I think also that I think it'd be prudent to set a date and put it in the divorce decree, and so all parties know when that's going to occur. Any comment on that? Or should we leave it with a 1 week notice and it has to occur within 60 days? Ms. Lindsay?
Yeah, that would be fine. I was wondering if it could be by text message because I wanted to make sure that my whole family knows is officially contacted and we don't miss the notification of the day, and also that can it be through a towing service, the pickup of
Yeah, as far as the text message, I'm fine with that as far as a notice. I do think that we should set a date here and put it in writing. And then any communication related to the move in vehicles, communication through the text, I'm fine with that. As far
You're
as go ahead.
just given the history of the emails and stuff that she sent me, I really would not want her having 24/7 access to my phone. You know what I'm saying? Sending me texts in the middle of the night and stuff. I'd really prefer that we keep it with email.
oh, grow up.
Oh, wait. So there, right now, there's a restraining order that prevents Mr. Lindsay from contacting Ms. Lindsay. The dissolution decree indicates that communication related to this exchange of property or the retrieval of property is excluded from that and is not a violation of that. Obviously, Mr. Lindsay, your concern, if that becomes a concern, then certainly you could file some type of anti-harassment or similar type of protection that would put a stop to any late night texts or what have you. So I think what I'm going to do under paragraph 8, the property will need to be retrieved no later than September 24th. That's the deadline. And then that's the latest time it could be removed. And so I'm going to set a date for the retrieval date is going to be on September 19th. September 19th is going to be the retrieval date. And so that's leaves a little bit of wiggle room, when sometimes, there may be issues in retrieving all the initial property on that particular date, and that allows a little bit of wiggle room. And so the deadline is the 24th of September, but the retrieval date is going to be on September 19th, which is a Saturday.
That's a lot of cars to move in one day. But
I agree.
Thank you.
I agree. And then I'll allow for a provision of text messaging if there, subsequent to the initial retrieval date of the 19th, if there needs to be additional time to retrieve, but the absolute cutoff deadline is September 24th. Okay. Other than that, other than the property exchange, I'm including I'm going to include the language as far as the sale of the property. That if the parties cannot agree upon a real estate agent, both parties are required to exercise good faith in choosing an agent. And if you can't, then you'd have to come back to court. And then as far as the terms and price and marketing, if you can't come to an agreement on that, then the real estate agent is going to be in charge of that.
I have submitted an agent, Your Honor, but the respondent did not on that one.
Right, I did notice that you suggested a real estate agent related to that. Okay, so let me touch base with the parties. As far as the divorce decree, any other adjustments or concerns? And I'm working off of Ms. Lindsay's proposed orders.
Yeah, the mini bikes and go-karts did not end up in your written decision. Although we spoke about them again during court.
And I think under Exhibit B of Ms. Lindsay's, there it has go-karts are listed as going to petitioner.
In her proposed.
Yes.
Your Honor, there's, oh, I'm sorry.
Go right ahead.
There's only one go-kart and there's always been one go-kart. It belongs to my son, but
Okay. So
Yeah.
yeah, I'm gonna list go-kart there.
um there's only one. There's I can't produce more than one. And
Your Honor, the other one is a frame that is in the garage. It is there with all of its steering components and suspension under the car, basically.
So what I'm going to do is under Ms. Lindsay's proposed Exhibit B, it says go-kart, and I'll just add and related parts.
Your Honor,
But
I really he came and he cleaned out everything. I feel like I should not be responsible for, what if there's a part missing? And also for 15 years, we never had a go-kart put together. So why would he have? I'm really concerned about having pieces, and then him saying, "Oh, it's missing a wheel." And I honestly, he cleaned out he took all the equipment, he took all everything, all of the lawnmower parts. He took he took all the gear. So how do I know that he didn't already take that stuff and he's just, saying that it's there? And this is missing items. I don't want to be held responsible for pieces of stuff that he has already picked up.
Your Honor, I submitted video and well, I have the video and I submitted declarations from people who were there. And as you've already stated, the one go-kart and all related things. And then again with the mini bikes there, he just keeps forgetting that part.
all right. So with the proposed order submitted by Ms. Lindsay, it lists go-kart, and I'm going to add the phrasing and related parts. Then as far as the mini bikes, Ms. Lindsay, do you have any concerns if that were to be added, or do you have any objection to that?
Yes, I do. Those were not addressed in the hearing at all, and also those were gifts to my children, and they are adults now, and they have taken possession of them.
Okay, so
Your Honor, they weren't there when I went to retrieve my personal belongings. They were
Because
not gifts. There are 4 mini bikes and 3 kids. The math don't math.
so let me double check my notes from the trial.
Oh my gosh.
One moment.
Did you receive the MSOs that I submitted, Your Honor?
MSOs?
The manufacturer certificate of origins. I have 2 of those mini bikes are actually titled in my name.
Okay. So as far as my notes from the trial, I see under direct examination of Mr. Lindsay, his testimony indicated there's 4 mini bikes he used to ride with the kids. They're gone. 2 are titled in his name. 2 are not titled in his name. Value is roughly $2,200 for all 4. He indicates that he does not know where the mini bikes are. That was one bit of testimony. Then,
But he never said that he wanted them, and also he gave them to my children. And
When?
And then,
on Ashley's birthday.
so then there's additional reference in the testimony under Mr. Lindsay, indicated he still doesn't have all of those tools, talked about an OBD tester, laptop and printer, hand tools, the mini bikes and go-karts.
He
So
took over
that's-
$100,000 worth of stuff. He took so much stuff. I don't even have a hammer.
So that's the testimony that was related to the go-karts. In my written decision, I don't think I addressed, pardon me, the mini bikes. I don't think I addressed the mini bikes. Is that accurate?
Yes.
Okay.
Your Honor, those are possessions of my children. They were off riding them when he came.
Okay. So as far as the mini bikes, we addressed the go-kart and go to on the parts related. Now, as
Oh.
far as let me finish. The mini bikes, I'm just going to omit that. That's not going to be included in the award to petitioner. That's not going to be included, so it's not awarded. Any other concerns with the decree? Again, specifically, I'm looking at the proposed order, final dissolution order, divorce order proposed by Ms. Lindsay.
So the attachment is going to be adopted. The community property debts that I attached, that's going to be adopted.
This is your updated one.
Yeah, that's gonna.
So did you, this is Exhibit C, the updated community debt, Exhibit C.
Yeah, is that going to be adopted with the specific naming and the spelling correctly of capital?
Mr. Lindsay?
I'm shrink. This appears to be out of order. Oh, I'm sorry. I'm looking at the wrong one. I think as long as it follows Your Honor's 5347 formula, I'm fine with it.
Bear with me one moment.
Okay, thank you.
Okay, so yeah, the revised community C, pardon me, revised Exhibit C community debt. I'm going to use that, but I'm adding the WSECU to Mr. Lindsay, 53% of that, and 47% of that to Ms. Lindsay. So I'll use that Exhibit C. All right. Any
Yeah.
other? Go ahead.
I'm sorry. Is there a way for me to find out the exact debt or how I would pay it, or how much the debt is, or is he paying on it? Can I find any details about it, or how much the debt was originally, or anything like that?
Mr. Lindsay?
I can forward her the account number and the current total via email.
Okay, and it should be the total as of May 22nd. So if there's been additional fees or charges incurred since that date, those would be excluded, but it's going to be as of May 22nd. All right, so does that answer your question, Ms. Lindsay, as far as gaining access?
Yeah, thank you very much.
Okay. Again, looking at the final dissolution decree, any additional concerns? Otherwise, what I'm planning to do is making those amendments that we talked about and then sending each of the parties a copy of that, of the final final submissions with those changes.
Yeah, Your Honor, she had talked about I think you already told her she's not going to double dip it on the retirement account. And those totals were 20 something at the date of separation, correct?
As of the date, yes.
Okay.
You're just adopting the order that I proposed for
Right.
dividing retirement accounts in marriage of dissolution.
Right.
Yeah,
That's basically 11,557
yeah.
to Ms. Lindsay, and then so that's the defined contribution account. Then there's the defined benefit, which is 161 a month.
It's one in the same account, though, Your Honor. The defined benefit comes out of the contribution. It's $11,000. That's what it is.
Yes, that's correct.
So if it's one in the same, Ms. Lindsay, help me understand, if they're one in the same, is it a defined benefit or is it a defined contribution plan?
I'm sorry. It's, oh my goodness. It's two separate, it's one account, and I think he would be able to explain it better. It's one account and it has a deferred it has a it has it has two separate elements to it.
What one is what the employer puts in, one is what I put in, and that comes out to the total of the 23,000 or whatever.
Yeah, it's not double dipping or anything like that.
No, so
there's a contribution by the employee, and then the employer makes a contribution, and then when retirement comes, then there's the lump sum, and then that can be utilized as desired. And then is there a defined benefit that comes out from that?
no, I believe the defined benefit would be what happens if I retire today. I get $161 a month.
Okay. And then what about so do you have to make an election of a defined benefit or the defined contribution benefits?
No, I believe the default is the defined benefit is what they would pay, and then the other if you I don't know if you can take a lump sum out of that. I'm sure you can, but there's probably be penalties.
Right. So if you were to retire, say at 65, then your only option is to get a defined benefit as opposed to declining that and then just taking withdrawals as one might.
I'm a few years away, so I don't know. I haven't looked into it that deeply.
Okay. All right, Ms. Lindsay.
I was just going to say that the Washington Department of Retirement, they helped me fill this out with because I subpoenaed his records, and the person who deals with his account helped me fill this out, and so I used his numbers from the subpoena. I don't know. I don't know what I'm saying, but it's not double dipping or anything like that.
Okay. All right. I think what I'm gonna leave it as presented as far as the defined benefit and the defined contribution. You know, the more common retirement accounts nowadays, at least, are the defined contribution. Entities are moving away from defined benefit because that puts more risk on them, and so they try to shift that risk to the employee by doing the defined contribution. So I'm going to sign off on the proposed quadro.
Okay.
All right, and if the two of you wouldn't mind just sharing emails with me again, so when I make these revisions, I can get them out to you today.
Mine, Your Honor, is Mr. M.R. Jamie L. Lindsay.
So Mr. Jamie R.
Jamie L.
L.
Lindsay at gmail.com.
Gmail. Okay. Thank you, Ms. Lindsay.
Lisa, Lisa 5057 at yahoo.com.
Yahoo. Okay, just to confirm both, Mr. Jamie L. Lindsay at Gmail, and then Lisa 5057 at Yahoo.
Yeah.
All right, I'll get on making those revisions right now, and you should have that hopefully before 11 today. Okay. Any final items?
Was there, did we have to do a child support?
No, the order that I penned was just relying upon the administrative order, just saying that that continues in effect. The tax exemptions are listed in the final divorce decree. And I think that that was summarized or at least noted in your proposed order related to the child support. Yeah, it says the court is not issuing a child support order, but there's an administrative order that's still in place.
Okay.
Yeah. Okay, Mr. Lindsay, any final items from you?
No.
Okay, all right. Thank you both very much. I appreciate your assistance and all the time and effort you've put into this, and I'll get those orders out to you today.
I appreciate that.